That'll be great. I think we've got our audience. Welcome, welcome. Thank you for joining. We'll let everybody assemble as we get started. You're here with Adam Glassfeld, All Rise News, and Michael Popok of Legal AF. We're getting the band back together again. I've been sort of off the Substack lives for the last couple of weeks, but I'm going to use this as an excuse to get back to my regular Substack living, and especially with Adam. Happy Election Day. We've got major votes against Donald Trump and for democracy in Virginia, the governor race, New Jersey, the governor race, Pennsylvania, the state Supreme Court vote of confidence votes there, the Prop 50 in California, municipal elections around the country. Now is the time, if you have an election going on, and hopefully you're registered, to go vote your displeasure with this insane, illegal, lawless Trump administration. Now is the time. It's good. It's as I just interviewed Senator Blumenthal. It's going up on Legal AF in about an hour. And he and Representative Grijalva, who I interviewed yesterday, said the exact same thing, not knowing that each other was going to say the same phrase, which is voting is a muscle. And it has to be used or it atrophies. And so this is a test run for the midterms. Find out if you're registered. Find out if your particular state has changed its rules of the game. Find out, make sure you can absentee and mail in and early vote and practice. Because this is the way. Yeah, crowds are great. I love marches. And court hearings are great. And polling is interesting. But nothing replaces standing in line or dropping off a ballot and registering your displeasure with the current administration. And so I'm glad people vote, and your employer has to let you off for the day to go vote or let you off. So that's illegal if they don't let you do that. Make sure that people here that are in those states have voted or will plan to vote today. So I'd be remiss if we didn't kick it off with that. So Adam and I were talking before we jumped on live, All Rise News and Legal AF. You could figure out whether you're subscribed to both or either. There's this little chyron, I think it's here, and you pop it, it'll tell you whether you're a subscriber. And that's the way you can show your love for what we do, keep us on the air, protect our First Amendment rights and your own, is through that. So when Adam and I were talking about getting together today, there's just so much going on that he and I are following at the SNAP payment for 42 million Americans, and whether billions of dollars are going to help the most disadvantaged people in America today or not. While Donald Trump trolls America on Election Day, we'll talk about that. There's a lot of moving parts down in the James Comey prosecution, with new filings in the last 24 hours, including a new emergency order just in the last few minutes from Judge Curry, who is not pleased with the indictment signer, Lindsay Halligan, in the Department of Justice. We'll pick up with that. And then a story that, Adam, you've been following very, very closely with Kilmar Abrego Garcia and his case to try to get his motion practice to try to get the indictment dismissed. And a development there, because I don't want to leave people with a cliffhanger. Like, wasn't that trial supposed to begin? And what happened with that trial? And then, of course, we can touch on Judge Immergut and her ruling coming out of Oregon, right? We've been following that closely, and what that means. Where another example of the Trump administration trying to stampede a judge into doing something or not doing something, and it backfiring once again. Which one do you want? I want to be a Glassfeld pick'em. Which one do you want to lead with?
Well, why don't we start with the latest in the Comey case, specifically the development that you teed up with Judge Curry. That Judge Curry basically had ordered the government to show the indictment signers' work before the grand jury. She wanted information for the appointments clause challenge, that before the disqualification of Lindsay Halligan. And apparently they didn't give the judge the goods. They didn't give a complete transcript. It makes one wonder what they're hiding.
I was going to say, you're being much kinder than you are usually. They're hiding documents from the judge.
Absolutely. And the judge said you have until tomorrow, Wednesday, to provide all the complete materials. I'm going to read the language of the original order. She asked for all documents relating to the indictment signer's participation in the grand jury proceedings, along with the complete grand jury transcripts. And they handed her a partial transcript. Did they think she wasn't going to notice that? And so it's just extraordinary that they're hiding the ball to the judge who has the power to decide A, whether to disqualify Lindsay Halligan, and B, whether because she is unlawfully appointed, if they find that the entire case should be dismissed. It's a hell of a way to start out that argument by hiding the ball with the federal judge.
Yeah, so let's unpack that. I've been doing this for 35 years in federal court. When a federal judge wearing a black robe tells you to jump, you say how high. When a federal judge says all documents related to the grand jury proceedings that you were involved with are to be delivered on my doorstep in my chambers for in-camera review by 5 o'clock on a date certain, you do exactly that without deviation. And the fact that they try to spoon feed her, as you said, as if she wouldn't notice. Judge Curry, a senior status judge in South Carolina, who's taking this very seriously. I mean, in order to decide whether under Section 546 there's been a proper appointment of Lindsay Halligan under the Vacancy Reform Act, that's a statutory interpretation. That's a construction. That's a reading and maybe of legislative history, and maybe like it was amended during the Bush administration. They put this language back in and that language back in. She doesn't need the grand jury transcript for that.
No.
What she wants and what the defense wants, because they've also sought the grand jury transcripts, is what the heck did the indictment signer, Lindsay Halligan, say to that grand jury? What did she she'd never done this before. This is like a brain surgery. This is like you and I going, I think I'll scrub in for brain surgery today. Well, where do I start? Okay. So she never is a federal prosecutor. There's magic language that you have to use, and then there's golden rules you can't violate when you present to the grand jury. She doesn't know any of that. How could she possibly have known what years of being a prosecutor would have taught you in terms of properly handling a grand jury and not violating the Sixth Amendment rights or other rights of the defendant? So the judge is like, well, I think she's looking for that, not only because she's curious, but because if she ever fashions a remedy, meaning if she finds that Lindsay Halligan was illegally appointed, the way the California federal judge, you did a great hot take on this, the way the California federal judge found that U.S. attorney was illegally appointed, the way that Alina Habba is going to get bounced in a certain way. If she finds that, then what? The defense is asking for the indictment to be dismissed. And she's trying to figure out what the indictment signer, was she alone? And what really happened there? And the part that I thought was fascinating from the order that you read,
Yeah.
to remind people that are joining the story in progress, is that Lindsay Halligan was so inept at her job that she walked out of the grand jury at like 7 o'clock at night, which is already late, probably holding them hostage and forcing them into an indictment. That's one argument. And comes out with two pieces of paper when she should have only had one. She comes out with two indictments, right, Adam? One with 3 counts that she signs, and one with 2 counts, which she signs. And the magistrate judge is like, I don't understand. Which is the true bill of indictment that was returned by the grand jury? Oh, there's only one, Your Honor. She says, well, I've got 2 pieces of paper here. So how did that happen? And Lindsay Halligan didn't know. So the judge says, I want all the documents and information and the grand jury information about the 3-count indictment, about the 2-count indictment. There's not supposed to be 2 indictments.
To your point, Michael, I think that this is absolutely about a remedy because we've been closely following all of this stuff around Alina Habba, Bilal Asaili over in Central District of California, Sigil Chada in Nevada. All 3 of those cases, federal judges looked at them, disqualified all of them without looking at the grand jury materials. They didn't need to. And in all of those cases, they did not dismiss the underlying indictments brought by the criminal defendants who were challenging it. And what this federal judge is doing, it seems pretty clear to me, looking at the grand jury materials, this is about whether the indictment survives if and when the federal judge finds that Lindsay Halligan has been illegally appointed. And just one more quick point, because just yesterday, Pam Bondi wanted to shore up everything about Lindsay Halligan by saying, oh, I have retroactively decreed as of October 31st that in addition to being an interim U.S. attorney, she's also a special attorney. So if you don't think she's a legitimate U.S. attorney, Your Honor, I've got another one for you. She was also a special attorney at the time. So
Nothing
decreed.
says I've got a problem like backdating a document, right? And nothing's, I mean, I've been doing law for a long time and you've been following law for a long time. I've never, no good has ever come out of backdating a document and retroactively trying to ratify something that happened. That means that their hair is on fire at DOJ. They should be. They're losing sleep. You've got two separate judges that refuse to call Lindsay Halligan the U.S. attorney. Judge Walker, in his orders related to Letitia James's case, because he's presiding over the main case, he only calls her the government counsel. He refuses to, and he says in a footnote, out of respect for Judge Curry, this judge that we've been going on about here, about the grand jury materials, out of respect for the fact that she has a pending motion to decide just what Lindsay Halligan is, I'm going to refer to her as government counsel. So Judge Curry calls her the indictment signer, and he calls her the government counsel. The only one that's calling Lindsay Halligan a U.S. attorney is Lindsay Halligan when she signs the papers in these cases, right?
Well, there's a whole broader conversation to be discussed about fake titles in the Trump administration, because no one calls Pete Hegseth in litigation the Secretary of War, because that's a fake title. That's not really, until Congress says there's such a thing as a Department of War and a Secretary of War, there is no such thing, and no self-respecting federal judge calls him that. And we're seeing the same thing happen with Lindsay Halligan.
That's a very good point. Immergat, who we're going to talk about in Oregon, refused to call Hegseth the Secretary of War. By the way, do you know, because I like anecdotal things, do you know why it was changed from the Department of War to the Department, and what was the Department of War, and why it became the Department of Defense after World War
II?
After World War II? Do you know why?
I think civilization decided that wars of aggression are a bad thing after the horror of World War II, but also Harry Truman, after a duly passed law of Congress, changing the way for the world order. I mean, it's ugly symbolism on top of everything.
But there's another reason.
Yeah.
Here's the other reason. The Army was always called the Department of War, not the Navy, not the other armed forces. So when they unified our armed forces, they couldn't use the Department of War because that was already taken at the time by the Army. Because it always, in real time at that moment, everybody who referred to the Army always referred to it as the Department of War officially. When they put it all together under one unified command, they decided to make, with the Marines and the Navy and the Coast Guard, they decided to get rid of the Department of War because the Navy would never agree. Because no self-respecting naval officer was ever going to let the Army's title be the name for the entire thing, right? So when they put it together, they made it the Department of Defense with the 5 branches of the armed services all nestled underneath it. That Donald Trump's bullshit story about, it was like a first woke moment in 1947. Because he's never read a book.
Right.
He doesn't know what the history is.
Right. And there are speeches of Harry Truman talking about turning the page with the signing of everything that created a unified, that we're setting aside the era of wars of aggression that this is. And so it on many levels, it's not it's decreed by executive order because you think it sounds cool. I think there's a kind of Orwellian aspect to the Trump administration where there are unofficial titles, and we're seeing it with these acting and interim U.S. attorneys. We're seeing it with the Department of War, the Department of Defense, and it's up to the courts and the press to call things by their actual name.
So Comey fought, just to stay there for one more minute. And thank you to the 1,200 people that took time out of their day, the election day here in America, to join Adam Klasfeld, All Rise News, and Michael Popok on Legal AF. We're back. Hit the free subscribe button. And if you can swing paid subscriptions on Legal AF, it's $6.77 a month or something like that. It's what pays to keep us on the air. It protects the honest reporting you've come to expect from Legal AF and from Adam Klasfeld independently and on Legal AF. So we ask for you to support us that way. When Adam goes on a trip, or if I go to Arizona later in the month to interview the 23 attorneys general for Legal AF, that's what helps pay the bills, that kind of thing. So Comey files a series of motions about the indictment, about vindictive prosecution. Letitia James is probably going to do the same thing. And we're all under a very short track here, right? Because the trials are in January.
Right.
Yeah.
Absolutely. As a matter of fact, the disqualification motion that we've been describing, I believe that comes to a head next week. Gonna have to make a trip over to Alexandria, Virginia for that.
Yeah. Is it going to be there, or is it going to be with Curry in South Carolina?
So I believe the arguments are taking place in Alexandria, but Curry herself will be in
See,
that.
you learn new things on our Legal AF Substack Live. I thought you'd be holding everything. We'd all have to go down to South Carolina and take a look at that. All right.
Apparently, I need to double check the docket, but
Yeah, before you book your flight, figure it
out. Precisely.
Right. All right. So let's move on from all things Letitia James and James Comey and Lindsay Halligan and Pam Bondi trying to wallpaper over major problems with her being appointed, and move over to what just happened in the last few hours, literally, about the $8 billion worth of SNAP food stamp type payments made to the most underprivileged people in America. We're talking about babies and children and veterans and disabled and seniors who need this money not to starve to death.
Right.
And the Trump administration, if they're playing games with Judge Curry, in their filings, they're playing games with Judge McConnell, and they got caught. And Democracy Forward, representing a whole host of public interest groups and church groups in Rhode Island, ran back to court in the last couple of hours while Donald Trump decided that on election day, he was going to be for people dying from hunger on his watch and refusing to comply with a court order. You want to tie that together for the audience?
Absolutely. Well, in one of the two cases where Judge McConnell ordered that replenishing the SNAP funds fully for the month of November, Donald Trump said, "Oh, what about half?" And so the attorneys for the coalition of groups that successfully sued for these SNAP benefits to be turned back on.
Well, one thing, what about half, and what about half a month from now instead of by Wednesday?
Well, because it's going to your point, Michael, you're right. It will take time to restart it. So they're trying to give half a loaf. They're trying to give it on a delay. And the coalition, I believe it's Democracy Forward, has put forward a motion to enforce the judge's order because it's a pending order. It's an order that's live. I want to make another point to your point, Michael. When Trump, late last week, after two judges said what you're doing with SNAP is illegal, he went on his Pravda, Truth Social, and said, "I do not want Americans to go hungry." But that's not how he ended the sentence. He said, "I do not want Americans to go hungry because the radical Democrats refused to do the right thing and reopen the government." So he had to fit in a swipe at the political rivals. He can't just express compassion for the poor. And the heavy irony here, as you know, this is a coalition of Democratic states, Democratic cities, and nonprofits that forced him by bringing two lawsuits by judges who are enforcing the law to make him do the lawful thing.
Did you see? But did you see the troll that he did this morning? He's not going to abide by the orders.
Yes. He
declared that the radical left won't let me pay, and it's suffused with fraud from the Biden administration. We're talking about food stamps. I tell people to, you always want to walk in somebody else's shoes for a moment, especially our audience does that here on Legal AF and on All Rise News. Think about going to the supermarket later today for your family and getting the necessary things that you need in your basket to have nourishment, to avoid hunger, the basic necessities, and you go to the checkout, and you have a half of what you need for the purchase in your pocket.
Right.
You think the supermarket's letting you go to the parking lot with your shopping cart? I don't think so. So people rely on this average payment of $350 per family. We're talking about 44 million families, 44 million people, 22 million households in America rely on this program. And what does the Trump administration say? They have some techno bureaucrat with just the indifference and callousness that can only come from being a bureaucrat, who says, "I'm the undersecretary of the Department of Agriculture." Well, good for you.
Hmm.
And into compliance with the court's order. It's always this Orwellian, we're going to comply, and then you have the thing that follows and it never complies. We're
Right.
only going to make half a payment, and we're not going to take the money from the other programs that we could have, the Section 32 funds, to make a full payment because, ha ha ha, we don't care about people suffering effectively. And on top of that, you say we have to do it by Wednesday. It's not going to happen. It's going to be weeks or months, he said in his affidavit. So Democracy Forward sees that and says, F that. They run back and file a new emergency motion with Judge McConnell. We're going to have to do another live later today because some combination of Judge McConnell and Judge Talwani in Massachusetts, who has an almost identical case, are gonna not be happy today, and we're
Right.
going to see what happens when a federal judge isn't happy. And
Right.
Judge McConnell is going to, I'm sure, either call a hearing and or issue another order. And in the meantime, Trump decides this is the moment to make human suffering a pawn in making a cheap political point against the Democrats, who are keeping the government closed or not agreeing to reopen it, if you will, to protect the same subset of underprivileged people who can't afford health care. It's the same group. The group that can't afford to eat is the group that also can't afford to have health care. And the red states and their attorneys general just sit on the sideline through human suffering and let the blue states run in. Look, the vast majority, there's a huge group of people in red states who are below the poverty line who rely on SNAP payments. And he's literally killing his own electorate and constituency.
Yeah. And to that point, just to make a note about something, and it might be trivia, but it's not. Judge McConnell, who's presiding over that case and who ordered this, he has been getting, I just checked this out right now, more than 400 threatening voicemails. One of those voicemails is now public. It's because he's ruled against Donald Trump in the past. The fact that he's still holding the administration's feet to the fire is a testament to the fortitude of the lower courts.
He got 400 now off the SNAP decision?
Not off the
Oh,
snap
just in
decision,
general.
just generally speaking over this administration, because it's not the first time that he's ruled against Trump, and
No,
this
he
is
did the
what
birthright
happens.
citizenship ruling, one of
Absolutely.
the top birthright citizenship rulings.
Right. And this is what happens now when you rule against Trump. And he recognizes that. It happened in the Chicago case of Judge Ellis, who's ordering the federal government not to shoot pepper balls or spray pepper spray in people's faces for no reason.
Like the clergy.
Like the clergy, and that's a new development this morning. And she announced when she got the case, as soon as she was assigned this case, she was preemptively threatened. But they're holding the line. They are enforcing the law when these cases and when these violations of the law are presented to them. They're not allowing the hundreds of threats to their chambers to cow them from doing their jobs.
Yeah, well, these are the federal judges that we have to applaud and find celebrate their courageousness, just like we do the public interest groups that run in and don't give the Trump administration any quarter. You see, they're a bunch of lying thieves. It's hard to believe, though, that this was a politically that he thinks this is to his political advantage to attack the underprivileged in America on election day, when I think by the time the day is over in Virginia, in New Jersey, in California, we're going to see the beginning rebuke in the polls, not the polling, against the Trump administration, right?
Right. I think Trump's calculation is that he thinks he can decree reality to section of the population who's not going to get the converse reality. And that if he declares it, and one thing that I will have to say, if you go to the White House website, they have a messaging for calling certain Democrats. He's animating and his supporters to blame Democrats, and that even when the facts aren't on his side, I think the kind of civic engagement is necessary. But unfortunately, with Trump's side, it is divorced from the facts. He is saying the Democrats are responsible for SNAP benefits being suspended when a coalition of mostly Democratic run cities and states have sued to force him to use the funds that are available to him and mandated by Congress for him to use for this very purpose.
Dare I say out loud that there is one person in America who controls all three branches of government during this shutdown? His name is the President of the United States.
Right.
It's not like he's got a problem with like the Democrats are in control of the House and the Senate. So his own party is not supporting him sufficiently on these major issues. While MAGA Mike Johnson, keeps the House shut so that we don't have votes about SNAP, so we don't have votes about Epstein, so he doesn't swear in Representative Grijalva. We see what's going on, and then let's segue to Oregon. You and I covered it. Judge Immergut, buoyed by the fact that the Ninth Circuit vacated an order that had reversed her decision about the deployment of the National Guard on the streets of Oregon. A 2-to-1 Trump panel had said, no, Trump's allowed to do it. I'm paraphrasing. And the en banc 29 judges of the Ninth Circuit said, yeah, we don't like that decision. We're going to vacate that, and we're going to revert back to Judge Immergut's 2 temporary restraining orders. So she moved forward and said, all right, let's have a trial, and let's get to permanent injunction, and you guys can do your appellate rights after that. Let's have a 3-day trial. So she had a 3-day trial last week, 750 exhibits or more, bunch of witnesses, and she was working on her order, which was obviously going to be against the Trump administration on the issue of the takeover of the state militia and the deployment on the streets of Oregon. So she asked the Trump administration at a hearing and all the parties, if the parties would agree to give her a week to write her order and agree not to deploy the National Guard for the Trump side in the meantime. And they said no. So she wrote a preliminary injunction order that came out a couple of days ago. And because she was forced to do it, in advance of her issuing her permanent injunction order about the case. Why don't you fill the audience in about all of that? Before you do, we have almost we have 1,600 people or more, 1,700 people or more who have joined us. We appreciate each and every one of you. If you wonder why some people are able to leave comments and you're not, that is about paid membership. So if you can become a paid member, you not only get this recording when it's all over, because some people are joining in progress. It'll post in, I don't know, between a half an hour and a day. It depends on Substack Live, how they do it. But you'll get the recording. That's good. You'll get to participate here with comment. And you'll have to support the honest commentary and journalism that's going on with Legal AF and with Adam Klasfeld's All Rise News. So that was a little bit of a pitch for us. Find out here, click the button. It'll tell you whether you're subscribed, and then you'll have an option to become a paid member as well. So why don't you update on the judge's preliminary injunction order, which only is going to last until like 4 days or 3 days.
Right. By Friday, she will fashion her permanent relief, and we'll be reporting that news. And there's no doubt where this is going. She started out everything by saying that Trump was untethered to the facts when he said there's a rebellion or some sort of inability to enforce the laws of the United States. And then there was a trial, and she was validated on that. There was nothing happening on the ground in the days leading up to Trump's order to send in the troops to Portland. So she issued a preliminary injunction that is in place. The Ninth Circuit, the Ninth Circuit's en banc court, as you said, buoyed her decision by vacating the 3-judge panel's order. And it's very clear where the winds are blowing here. That preliminary injunction is in place until Friday, and we'll see what she writes in this permanent injunction, because the point that I think both of us have made a couple of times, Michael, is that Judge Emmerichs is a Trump appointee, and her initial ruling was very scathing. And now she has a 3-day trial record to point out the evidence that we learned throughout that trial and to find out what officials for the government observing this on the ground have said. I have a feeling that whatever comes out on Friday is going to be twice as scathing as the order we've been quoting nonstop, where she,
Especially now that she's pissed off.
yes,
I mean, you see now the judges, especially depending upon like their status and how long they've been around, they're trolling Trump right back. Like when McConnell issued his temporary restraining order, the Trump in the SNAP funding cases that we just started talking about at the top of this live, he started it with he issued an injunction from the bench orally, which is totally fine, by the way,
yeah,
because there's a recording, and he can say for you don't have to issue it in writing. That wasn't good enough for the Trump administration, so they file an emergency motion to have his temporary restraining order reduced to writing, and in it they wrote, because of the logistical issues and decision making that we have to use in order to get the payments made, we need a written order. And Trump had done the posting that you talked about on Truth Social about he's going to pay. So the judge said, "Good to see that that Donald Trump has acknowledged that he's going to pay, and it's good to see that you've acknowledged that you're going to cut through all the red tape and get these payments made. So here is the clear direction that you've asked for." I mean, he literally wrote it that way. They're getting fed up too, federal
right,
judges, with the games playing. And the flirting with contempt behavior and they don't believe a word the Department of Justice is saying to them. It's the
right,
first time in history where the Department of Justice is completely lacking in any credibility in front of a federal judge. Just none of them. I don't care if they're a Trump appointee or they're not a Trump appointee. You take anything the DOJ says with a grain of salt. You have a jaundiced view of whatever they say, and you don't believe them. And that's what we're watching in federal courts and grand juries and juries. It's just this complete lack of credibility because it's all been destroyed by Donald Trump and Pam Bundy.
And as we both know, the jargon for that is the presumption of regularity. And you have federal judges saying on the record over and over again, you have destroyed the presumption of
Now,
regularity.
that's a very good observation, because that was shorthand for judges to say, "I'm not going to get into all the mechanics of like how you filed this or what your process was or what you did in the grand jury. We're going to presume, unless it's shown to us otherwise, that it's regular, that you followed your regular conduct." That's the presumption of regularity that Adam just mentioned. But the federal judges are like, "Yeah, you don't get that deference. You don't get that presumption because we don't
And
believe." We used to joke, like when I practiced regularly in state court, if you came in like I did with a really well-known firm where because of years of experience, judges could trust you as an advocate to be candid with the tribunal as is required by your oath. And you may not they may not agree with your analysis, but they know you're not going to intentionally lie to them about the facts or lie to them about the law, even if it's against you. And so when you have that credibility, it's a tremendous amount of wind at your back when you're arguing emotion. And we used to joke that the tie goes to the runner. That if it was a close call in a case, if they believed you and they believed in your honesty, your integrity, and your credibility, then you got the win.
right.
The Department of Justice there's no ties going to the runner with this Department of Justice at all. In fact, did you see the sentencing on Toronto and what happened with the fired Department of Justice lawyers showing up for the sentencing with Judge Nichols?
Oh, yes, that's the one, the pardon January 6th rioter who threatened President Obama.
Right, who live streamed a bomb threat again while he
Yes.
rode around his neighborhood. And then
So I followed it offhand. I'm wondering which aspect of it that you're talking about.
So they go to sentencing. They sidelined, I'm sure they're fired now, the two U.S. attorneys
Yep.
the assistant U.S. attorneys who filed a sentencing memorandum that contained a paragraph that reminded the court, and this is Judge Nichols, he knows Jan
Right.
6 pretty well. He was the judge presiding over the Bannon sentencing. He's a Trump judge, but he also sentenced Jan 6 people. He was upset about the immunity, the pardons. So, so they had a paragraph that said this Yahoo was also part of the mob and the riot that attacked the Capitol. And they
A
mentioned
plain fact.
a fact. And they mentioned also that Donald Trump doxed Obama by giving his home address that this guy then used to go find him in that neighborhood in Washington, D.C.
Right.
So Jeanine Pirro, I guess the MAGA right-wing social media influencers like Laura Loomer saw it, and then they tried to file a replacement for that document and withdraw the first document, which you can't do without
Right.
court approval. So they filed this, and now their names are off. That paragraph is missing. So when the judge noted that the two suspended lawyers were in the gallery, sitting with other Department of Justice fired officials who had joined them in solidarity, the judge took a moment to compliment them for their candor,
Right.
for their ethics from the bench.
Absolutely. Well, that's the thing about the District of DC bench. They saw every single judge on that bench went through these thousands of cases and including the hundreds of violent cases. They saw the video of a police officer being tasered, many police officers being pepper sprayed, people using handmade weapons, whether it's metal barricades or a fire extinguisher, and they've seen all of this horrendous violent activity. So when someone comes to court and tells them, "Oh, don't call it a mob, don't call it a riot," that's how you torpedo your credibility. I just couldn't understand how Ed Martin got anywhere near the U.S. Attorney's Office for D.C. to begin with. That's one way. I mean, just putting him in that perch, having an apologist for January 6th in that perch is a blaring signal to the D.C. Circuit bench. Do not trust anything this Justice Department says. And of
Absolutely.
course, he wasn't long for this world. He's out of there. But just that was it just showed that on top of everything else, on top of the outrage of pardoning every January 6th rioter, there was also the fact that it was strategically remarkably stupid. It is a way to guarantee that the District of DC bench rules against you because even the Trump appointees saw the extreme violence meted out on law enforcement and other people on January 6th. They're not going to buy this administration's propaganda about it. And if you want to ruin your credibility in one fell swoop, just install someone whose claim is, "Oh, this wasn't a big deal." And
You
that's
know,
what they did.
Senator Blumenthal, who's on an interview with me right now on Legal AF, we interviewed him yesterday. He said he's the ranking member on the Senate Permanent Committee on Investigations. And he talked about the difficulty as a minority party to hold Donald Trump accountable and also, to try to defeat the weaponization of the Department of Justice. And we talked about his cross-examination of Pam Bondi and all of that. But one thing he said was one of the things that, and I never really heard it expressed this way. One of the things they're waiting for is inevitably the whistleblower from within the Department of Justice. They already have cooperators who are working with this is interesting. This is a little breaking news. They are already working, that committee, the Democrats, with alumna who have left the Department of Justice, some of them quite recently, about what's going on inside.
Right.
But they're also waiting for the courage of that whistleblower who's still there to come forward and rat out this administration, Pam Bondi, Todd Blanche, Stan Woodward, and the rest about what's really going on inside of there and come and testify. They also said they're gonna work hard to get Jack Smith in at least a shadow hearing to testify to the Senate Democrats and the American public, which we know Jack Smith is chomping at the bit because he's let it, right? You saw the reporting, he's let it be known that he's looking forward to the day when he can tell the American people that which the Supreme Court and Judge Cannon would not allow.
Right. And of course, yesterday, the 11th Circuit telling Judge Cannon, hurry up on volume two. There's a pending matter. Will she release that report? Well, if Jack Smith testifies publicly, one of the things that he asked permission to do is be able to talk about that other half of the report that he authored about, and the only special counsel's report in history not to be made public after an investigation has ended.
I've been
So that's
calling
a
for that with the everyone's, I'm all in favor of the Epstein files being released in their entirety and siding with the survivors about that as well. But I've been demanding volume two since Merrick Garland did what I thought he was going to do, and I hoped he wouldn't do, which is to leave a love note for Pam Bondi on the desk upon her arrival saying, attached please find is volume two. I'll leave it to you to decide whether to release it. He had time. Jack Smith signed volume two about Mar-a-Lago and the criminality of Donald Trump on the 7th of January. Merrick Garland had from 7 Jan to Jan 20 at noon to release that effing file. So what would have happened? So what? MAGA would have been upset? More than they are now? More than they lie about Biden and Merrick Garland now? He's already in the crosshairs to be indicted by Lindsay Halligan. He should have
right.
released it for posterity to the American people so that we would have read it. And that was another major faux pas among many about the reign of Merrick Garland. I mean, other
I
things
I I
I things
I
I
want
like about him, but not that.
I wonder what day specifically Judge Cannon interceded. It's so long ago, but it's just shocking that she even essentially put it off indefinitely with her injunction blocking the release. Originally, she wanted to release both. She wanted to block both volume one and volume two. And then she had both volumes in front of her. And the whole rationale for it was, well, the charges against Trump are gone, but technically Walt Nata, Carlos Oliveira, his co-defendants, they're still potentially standing trial, and well, we can't release volume two because that will interfere with their rights to a fair trial. As if anyone believed for a second that the Justice Department was going to prosecute Trump's co-defendants. And
Right.
lo and behold, they dismissed the case. So what's the holdup?
And,
The
and who
holdup
and
is
who and who was their and who was counsel for the co-defendants at Mar-a-Lago? Walt Nata and Carlos de Oliveira.
Dan
Stan
Woodward.
Woodward, who's now number 3 in the Department of Justice.
Yep.
You
Yep.
know,
And now helping argue against the vindictive prosecution motion brought by Kilmar Abrego Garcia.
I know
It's a
people remember, you will because of the way you follow your cases. You remember Stan Woodward accused the then Department of Justice in the Mar-a-Lago case of trying to extort him, right? That he was in a room with the head of the National Security Unit, who was the lead prosecutor in Mar-a-Lago, along with Jack Smith. And and Stan Woodward started crying about, oh, I was in a room and they told me, oh, we heard you wanted to be a judge in D.C., and you think you're going to get it now if you're going to represent, these guys or whatever, and like crying about the way he was treated by the Department of Justice. Look how his Department of Justice is treating people now.
right. Right.
You know,
To bring something full circle, when we talk about the Department of Justice, number one, Trump's former defense attorney, Pam Bondi, for the impeachment. Then Todd Blanche, number two, the former criminal defense attorney. Stanley Woodward, number three, represents all of these Trump allies and co-defendants. And to bring it back to where we started, which was the Comey case, this is what the government is saying. A duly appointed and unbiased prosecutor presented this indictment. Another Trump attorney, Lindsay Halligan,
right?
unbiased, just following the facts and the
And,
law and ignoring all of her career prosecutors.
and number 4 in the Department of Justice is the Solicitor General, who
Correct.
just as a little plug, tomorrow, Wednesday, and I'll mention this to you too, Adam. Wednesday, we have at 10 a.m. A landmark oral argument about whether Donald Trump's ability to tariff 138 countries, which is the framework of his entire domestic and economic and foreign policy, whether it's illegal or not. And it's going to be heard tomorrow in front of the Supreme Court. We're going to live stream it. on Legal AF, because we live stream now under the live tab on the YouTube channel for Legal AF, all of these major oral arguments. And then afterwards, I think Adam, you and I are going to get together. I'm going to have Lisa Graves, who's along with us on Legal AF and with Court Accountability Action, who just wrote a book about the United States Supreme Court, and John Roberts in particular, join us, and the three of us will kibitz about what we just heard. I'll tell you straight, I'll do a little cliffhanger, or a little preemptive. If I don't hear in the first 5 minutes from the questions being asked the term major questions doctrine, then I know we're sunk, because I don't know how the Roberts Court, who invented the major questions doctrine, which effectively says that you can't use interpretation of statutes for major issues. If the Congress wanted you to have that power or that ability or that program or that right, like forgiving student loans, they wouldn't have buried it in some text. They would have a separate affirmative statute on that particular issue. So they call that the major questions doctrine. So when Biden tried to get rid of student loans and forgive them, well, what's the power for that? Oh, it's right here in the Department of Education about blah, 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 about contracts. They're like, oh no, that's such a major question. We would have expected Congress to have had a clear instruction to the president that allows that power. We were like, all right, well, we never heard of that doctrine before, but okay. So what about now? So IEPA, the International Economic Emergency Powers Act, which doesn't even mention the word tariffs, is the thing that gave Donald Trump the power to tariff. Why isn't that a major question, since it's Congress's right to tariff, not the president? So if I don't hear the MAGA 6 start talking about major questions doctrine, then you know it's all cooked. The cake is baked.
Right, absolutely. And I will note there was a very interesting interview. Scott Bessent, who's going to be in the room apparently because it's so central to Trump's economic agenda, was on CNBC, and he was asked a very interesting question about some future Democratic president might say that we need to take strong economic action on the climate emergency. And his response was, well, I don't think there's a climate emergency. And it shows he doesn't understand what these arguments are about.
Right.
They are arguing.
What's the emergency? The creeping trade deficit over the last 10 years? That's right. An emergency? Oh my God, there's a creeping trade deficit. What do we do? So,
yeah,
I mean, between the emergency and the lack of tariff mentioned in the statute, I don't get the arguments. Although you and I'll hear it, and then afterwards we'll have everybody join us on Legal AF for something related to it.
And just one more point on that. Yeah. For one, I mean, there is a climate emergency, but the whole point is, and to your point, no, there isn't an emergency that is that right now on trade deficits. But the whole point the administration is making is that, oh, you cannot judge. If the president says there is an emergency, at minimum, you need to give him a lot of deference. And so Bessent just shot himself in the foot. I wonder whether particularly the liberal wing of the court, they sometimes, I remember Sotomayor once tried to turn the question about the power of the federal judiciary. Hey, if a president took away all your guns.
Right. How would you feel about that?
Right. So I wonder if she's going to put
We're going to see. I mean, so tune in with, sorry, I didn't mean to step on you.
No, that works.
Yeah. So tune in tomorrow, Legal AF on the YouTube. Why don't you do 1 second or just on Abrego Garcia, just so people knew what happened, and then we'll be able to wrap up our live for today. In the meantime, hit that button, subscribe to Legal AF Substack, subscribe to Adam Klasfeld's All Rise News. You'll know whether you are. Some people might be thinking, did I subscribe to them? You'll know. Hit the button and it'll tell you. Then you can talk to us in the chat. Then you'll get a copy of this video when it's all up. I love hearts, but this is the way you support us as well. And then if you can swing a paid subscription, you'll see an option there for that. It'll open up a door to a whole nother set of content, and it'll keep us on the air, doing the things that we do, bringing in the interviews that we do, bringing in the commentary that we do. It's our First Amendment expression, but it's yours as well, to receive the honest commentary that we provide. And so we ask you to help us in that way. Why don't you catch everybody up on Rego Garcia's case?
Thank you so much, Michael. And that's a great note to end on.
Yeah.
I was actually supposed to be in Nashville today because there was going to be initially an evidentiary hearing today and tomorrow. That has been postponed for about a month. And to Michael's point, the subscriptions bring me to where the cases are. If it had the case been there, I would have been speaking to Michael today about that.
Yeah, right.
So
From Tennessee.
from
Right.
Tennessee.
Yeah.
And so there is now a little bit more of a delay. There's going to be, and there are two tracks of his case: the habeas corpus case, where he's trying to get out of immigration detention and prevent his expulsion to Liberia, and perhaps be deported to a different country like Costa Rica, which he would agree to. But as things stand, both those cases, the criminal case with the vindictive prosecution motion and the habeas corpus case for his freedom, those are on hold. There's going to be more briefings and there are going to be hearings. You'll know when those are coming up, and I'll be reporting live from the courtroom.
But one of the main reasons it's delayed is because the Trump administration, has dragged its feet about producing documents, and
Yes,
the defense has said, basically to the judge, they have the burden because the burden has flipped here. The burden is now on the government to prove that they did not vindictively prosecute um, Abrego Garcia, because he's already carried his weight to show that there's a presumption that he was vindictively prosecuted. So the
right,
shoe is on the other proverbial foot. And so
right,
the
and
government has to come forward with evidence, not legal argument of lawyers, not naked, we call it naked argument, not naked argument. It has to be like supported by, witnesses and documents, and there aren't any that have been provided. So you got the defense demanding documents and witnesses and emails and all of that, and the government saying, we're not going to turn it over to you. So the judges had to intervene. He's gotten a bunch of documents in camera for his review, but he's realized that the defense is right, that either they don't have anything and therefore he should grant the motion to dismiss the indictment, the government, or they have it, but they're foot dragging about turning it over. The judge has to solve that problem, get the documents over to the defense, and then let them have that 3-day evidentiary hearing, which has now been postponed until December. My gut feeling, based on the two judges that are holding Rego Garcia's liberty and life in their hands, is that he's not going to be deported or removed to Liberia or anywhere else, at least through that December hearing, while Judge Zinnes has given him deadlines on his habeas corpus petition about his due process violation and the remedy related to that due process violation. Because the open question I have, Adam, is, does the federal judge, Article 3 judge, have the power, based on a record that she develops, to order that he be granted asylum, that he not be sent to Liberia? Because what would you have to, if she finds a violation of his due process rights, which she's already found, and she finds habeas corpus is appropriate, then what's the remedy? It's
right.
not money. It's not money necessarily. It is something punitive to the government to make them think twice about ever doing this to somebody else again.
So
So one of the things would be, you dismiss an indictment if she had an indictment in front of her, but she doesn't have an indictment in front of her. She has his application to stay in America and not be sent to Liberia in front of her. So I think my gut, she's got the power to do it, and then she's waiting for the full briefing about remedy to see what she can do.
So I was actually in Greenbelt, Maryland for the last hearing on that. And what it seemed that she was leaning toward was releasing him from immigration detention. That is basically, it's under a Supreme Court precedent that the government needs to show that they're actually imminently trying to deport him, and that's why the government came forward and said Liberia all of a sudden. It threw a wrench
Right.
in things. Back to your other point, and a very astute point about the presumption, now the shoe being on the other foot that the government has to prove. It's worth noting the reason for it. It's because Todd Blanche decided to talk to Laura Ingraham and say, hey, this whole thing started because a judge said the judge questioned the propriety of deporting him. Well, that's pretty much saying you're retaliating against him for exercising his rights. And that's why the presumption, why that burden is now on the government. And
Yeah.
they don't want to put Todd Blanche on the witness stand. They're trying to quash a subpoena for his testimony.
Just play the tape. He's on Halligan. Halligan, he's on Ingraham. Ingraham asked him, like, how did the indictment come about?
Mhm.
And he effectively says, well, Judge Zinnes in Maryland accused us of doing something, so we indicted him in Tennessee. And the judge Crenshaw, in his order, said a version of, that's not only presumptive vindictive prosecution, I think that is actual vindictive prosecution by itself, and shifted the burden.
Right, right.
Yeah.
And he used the word strikingly, which, granted, it's not the strongest word in everyday life, but in a
Right.
judicial opinion, he's
Yeah.
referring to this really out of the ordinary statement by
Well,
Todd
thanks
Blanche.
for doing the hard work that you do on the ground. That's I always tell you that's your competitive advantage among lots of legal commentators out there. You get in the courtrooms, you get the reporting, you break the stories. I think Legal AF has its own competitive advantage to have contributors like you and the things that I anchor here on the show, and bringing our audience together. Look, 2,300 people said, that sounds interesting. Popok and Glassfeld got together? All right, let's go see what that's all about. While you're here, because we're about to sign off and it's been going on for almost an hour or so, if you want to get this video, become a member, become a paid member. If you become a member, you definitely get the video. If you want to help with the journalism and the honest commentary that we do here, it's becoming a paid member if you can swing. And I know there's a lot of competition for very scarce dollars today, especially given the Trump economy. I get it. But this is the way people say, how can I support Legal AF? Well, this is, and All Rise News, this is the way you do it. But at the very least, become a member. And you can check on that Chiron up there if you are already a member. And then, we'll get back, Adam, to doing this once a week, right?
Sounds great.
All right.
Looking forward to it.
Thank you for being here. Thank you for joining All Rise News and Michael Popok on Legal AF. This video will be up as soon as Substack says it's ready, right here on both Legal AF and on All Rise News. So until our next report together, Michael Popok and Adam Glassfeld signing off. Thanks all.